facts.
What is the maintenance sought for by the wife?
Maintenance sought 20,000 for the first petitioner and 10,000 for the second petitioner, my lord.
That is
There also he drank and came out there, made all mischief, and he made me to close down the beauty parlor. Now I am nothing. I am having
while granting divorce, permanent alimony is not granted.
not granted.
I appear for the respondent.
I appear for the petitioner, my lord. In this case, my lord, the maintenance petition filed by the me was partly allowed. That is, maintenance was rejected. Only educational expenses of my son was granted, my lord. And your lordship may kindly, I'll just read out my translated copy I filed, my lord. I'll just read out the facts in issue, my lord. The facts.
What is the maintenance sought for by the wife?
Maintenance sought 20,000 for the first petitioner and 10,000 for the second petitioner, my lord.
That is the son or daughter?
That is the son, my lord. He is he's the student. He is studying in law. He is now studying in law, my lord.
He is studying law.
Studying law.
How much the court has granted?
For educational purposes, my lord, only educational expenses must be borne by the respondent, not maintenance. Maintenance for both the.
No other amount is granted towards maintenance.
No other amount.
Education expenses have to be borne.
Only educational expenses.
What is the income of the husband?
Income of the husband, my lord, as per me, my lord, as per my.
Yes.
He has got the property and agricultural land at Madhapura village and residential house and residential Ramanalli village, and he is having monthly income about more 50,000. Though he is sufficiently capable of taking care of himself, having enough income.
What is the wife doing?
Actually, my lord, wife is now doing nothing. Actually, in the beginning, she has a beauty parlor. There also he drank and came out there, made all mischief, and he made me to close down the beauty parlor. Now I am nothing. I am totally depending on my parents.
Please come to the order.
From para 13 onwards, I mean, read me not.
Start from the reasoning, para number 10.
Okay, right now. Para number 10, my lord. According to the details in the petition, since the respondent completely neglected petitioner, for which petitioner number 1 started beauty parlor by borrowing loans. Even after that, the respondent who used to drink come near beauty parlor and behaved immannerly, for which most of the customers stopped visiting the beauty parlor, suffering from financial clog, she started relying on her deceased mother. While this being so, during COVID pandemic, she left respondent and returned to her own native and started residing there itself, wherein respondent completely neglected to take care of the petitioner. The respondent denied all these points and stated that since he became deaf and was incapable of continuing his driving profession, and hence he set up a beauty parlor to the petitioner number 1, and petitioner number 1, who started having income from the said profession, used to have inferior attitude against the petitioner who is deaf and completely neglected him, and then she expelled him out of the house, since had no income, and at present he is living under the shelter of his mother. Both the parties produced several evidences before the court in order to substantiate their arguments and objections. Among them, only few reliable evidences are taken for examination. Para number 12. It is undisputed fact about the relationship between the parties, and that the petitioner is residing separately from respondent. Exhibit P1 exhibit R5, invitation, exhibit P2 and P6, photos, R8, birth certificate of the petitioners. Notice are all also undisputed and are supplemental to this case. Though it is the stance of the petitioner that the respondent himself abandoned this house and have neglected her, the supplementary evidence to prove the stance of PW1 are not available before the court. Also, any factors admissible for the allegations are not brought out in the cross-examination of RW1. In Exhibit P14, diverse notice issued by petitioner number 1 to the respondent on 28/12/2018, it is alleged that the respondent has caused physical and mental torture and abandoned her. But the document marked as Exhibit P15 as regards to the discussion permitted to petitioner number 1 by Mysore Women Police Station on 9/12/2018 and excluding the medical certificate marked as Exhibit P18 issued by the medical officers of Primary Health Care Center on 22/12/2018, and that she took treatment at Primary Health Care Center at Hale Agrahara on 10/1/2018, that her husband had assaulted on her about 3 days ago. There are no other documentary evidences before the court to conclude that the respondent has caused harassment on petitioner number 1 during the period of 16 years of marital life between petitioner number 1 and respondent. Moreover, PW1 herself during the cross-examination has adduced that she is not ready to live with the respondent. When all these factors are carefully examined, it could be concluded that there are no enough reasons to show that the petitioner number 1 is not capable of living together with the respondent. Hence, as provided under section 125 clause 4 of Criminal Procedure Code, it could be seen that the petitioner number 1 who is living separately from respondent number 1 is not eligible for culminating maintenance from him. Moreover, the important point to be noticed here is that the petitioner number 1 has filed MC number 214 of 2022 before the so-and-so court, Mysore, against respondent seeking divorce. The said case was transferred to this court and the same was simultaneously inquired along with this court, and the said divorce case was ordered, under which petitioner number 1 got divorced from the respondent. Despite there are no documents in this court, the said fact may be considered by the knowledge of this court. Hence, as explained in section 125 of Criminal Procedure Code, the petitioner number 1 does not come under the purview of wife, but she comes under divorced wife. And hence, though the divorced wife being petitioner number 1 has no source of income and the respondent is well stable in terms of income, if she proves that he has denied to take care of her and has neglected her, and then she would be eligible for maintenance from respondent till her remarriage or lifetime.
No, while granting divorce, permanent alimony is not granted.
Not granted.
Yes. What do you say, counsel for the respondent? What is this finding of the court that even after divorce also she is not ready to stay with her husband? That's why under 125(4) she is not entitled for maintenance.